There are moments when a system does not collapse loudly. It doesn't announce failure, it simply pauses, hesitates, and then does something it has avoided for years. Those moments are easy to miss because they don't look dramatic at first. They look procedural, almost boring, but that is usually how the real fracture begins. For a long time, consequences existed here only as an abstract concept. Courtrooms became stages. Sanctions turned into background noise. Formal warnings lost their weight through repetition. Each boundary, once tested and not enforced, quietly rewrote the rules. Not on paper, but in behavior. And when that happens often enough, the system starts behaving as if enforcement itself is optional. What made this moment different wasn't outrage or spectacle, it was timing, precision, the absence of theatrics. A decision delivered not as a threat, not as a signal, but as a conclusion that had already been reached somewhere off camera. The kind of conclusion that usually takes years of restraint before it is allowed to surface. Inside a federal courtroom, something shifted. Not suddenly, not impulsively. It unfolded over hours under fluorescent lights, in full view of procedure. Instructions were given. They were acknowledged. And then, one by one, they were ignored. Not accidentally, not emotionally. Ignored in a way that suggested expectation, as if the response had already been calculated in advance. This wasn't a heated exchange or a breakdown of decorum. It was repetition. Interruption after interruption. Statements delivered at moments chosen for maximum exposure. Silence requested, then violated. Authority asserted, then tested again. Each time the system responded the way it always had before, with warnings, pauses, patience, and each time that patience was read not as restraint but as weakness. At some point, the courtroom stopped functioning as a neutral space. The presence of jurors changed the temperature. Words landed differently. What might have sounded like rhetoric elsewhere took on a different character when spoken directly into the machinery of a trial. At that point, it stopped being about expression and started becoming interference. This is where it usually stays unspoken, because acknowledging that shift forces an uncomfortable question. What happens when the court itself becomes the target? When the disruption isn't incidental but strategic? When defiance is not a byproduct of emotion but a method? For hours, the system tried to absorb the pressure. It issued clear instructions. It documented violations. It escalated language carefully, as if hoping the accumulation itself would restore order. But accumulation can work both ways. Sometimes it restores balance. Sometimes it proves that balance no longer exists. By the end of the day, something had to give. Not because of anger, not because of politics, but because the mechanisms designed to keep proceedings intact were no longer functioning. And when that happens, the system is left with only one option it almost never wants to use. The decision that followed did not read like a warning. It read like an autopsy. Methodical. Specific. Unemotional. A record of moments that, when viewed individually, might seem manageable, but when placed together formed a pattern that could no longer be ignored. This is the point where the story becomes uncomfortable, because it's no longer about one person's behavior. It's about whether the rules still mean what they say, and whether the institution enforcing them is willing to act when restraint stops being a virtue. Once that line was crossed, there was no clean way back. The system could no longer pretend it was dealing with isolated incidents. What emerged instead was a mechanism problem, not a personality conflict, not a political clash, a failure mode. Courts are designed to absorb disruption up to a point. Warnings are not symbolic. They are calibration tools. Each one is meant to reset behavior without escalating force. But that only works if the subject recognizes the authority issuing them. When warnings are treated as noise, the court is forced into a corner it is structurally reluctant to enter. At this stage, intent becomes everything, not motive. Intent. Whether the behavior shows awareness of the rules and a conscious choice to override them. And this is where the system starts documenting instead of reacting. Timestamps, sequences, context. Not to persuade the public, but to satisfy a much colder requirement, proof that restraint has failed. The interruptions were not random. They coincided with moments of maximum institutional vulnerability. when jurors were present, when rulings were being issued, when the procedural flow mattered most. That pattern matters because it removes ambiguity. It stops being about speech and becomes about obstruction. Not in theory, but in practice. This is the quiet detail most people miss. Courts do not punish defiance, they punish interference. The moment behavior begins to alter the conditions of a fair trial, the system reframes the problem entirely. Free expression is no longer the lens. Preservation of process is. At that point, civil tools stop working. Fines lose meaning. Warnings become redundant. Removal from the room becomes a temporary patch, not a solution. The court has to decide whether it still controls the space it is responsible for. And that decision is not emotional. It is mechanical. The referral that followed wasn't escalation for its own sake. It was an admission that the normal hierarchy had inverted. The defendant was no longer responding to the court. The court was reacting to the defendant. And that inversion cannot stand without rewriting the idea of authority itself. This is why such referrals are rare. Not because the conduct never happens, but because the implications are severe. Once the criminal mechanism is triggered, the trial splits into parallel realities. One process trying to adjudicate the original case, another forced to defend the integrity of the first, and this is where the system begins to strain. Because now every choice carries consequences beyond the individual. Declining to act sends one signal, proceeding sends another. Neither option is neutral. Both reshape expectations for every courtroom that follows. The technical question becomes brutally simple. If orders can be violated repeatedly, in full view, with documentation, and still produce no decisive response, then those orders are no longer orders. They are suggestions. And at that point, the system stops functioning as a system. This is why the language of the referral is so precise. It doesn't speculate, it doesn't editorialize. It establishes sequence, awareness, repetition. It builds a record that removes discretion from the next step. Because discretion is what failed earlier. And now the process has entered a zone where timing matters more than rhetoric. Deadlines replace debates. Decisions replace commentary. The machinery is moving not because anyone wants a spectacle, but because stopping it would mean admitting something far worse. The uncomfortable part is that this is no longer contained to one courtroom. Every institution watching understands the precedent forming in real time. What happens next will define whether authority still travels downward or whether it has already begun leaking upward. At this point, the system usually fails, or it hardens. And the difference between those outcomes is decided quietly long before anyone is ready to say it out loud. From here, the consequences stop being abstract. The machinery doesn't ask what should happen. It asks what must happen to preserve coherence. And that distinction matters because once the process reaches this stage, personal narratives lose relevance. The immediate effect is isolation. Not symbolic isolation, but functional. A defendant who cannot be physically present stops being an active participant and becomes an observer. That shift changes everything. Strategy collapses. Control evaporates. The courtroom no longer reacts to presence, posture, timing. It moves forward without accommodating disruption. Silence is enforced not by persuasion but by architecture. This is where the system reasserts itself in its most impersonal form. Proceedings continue. Testimony unfolds. Decisions are made in rooms where the disruptive element is no longer allowed to interfere with flow. What was once a performance space becomes procedural again. And for a defense built on visibility and pressure, that transition is devastating. Beyond the room itself, the ripple spreads outward. Prosecutors are no longer weighing optics. They are weighing institutional survival. Declining to act now would not preserve neutrality. It would redefine it. It would signal that documented defiance, repeated and deliberate, is survivable if the defendant carries enough weight. That is not a legal adjustment. It is a structural surrender. Proceeding, on the other hand, fractures time. A second legal track emerges alongside the first. Parallel processes competing for attention, resources, legitimacy. One determining guilt or innocence. the other determining whether the rules of adjudication still exist. This is how systems exhaust themselves, not through collapse, but through overload. And there is a deeper risk that rarely gets stated. Once authority is restored through force rather than consent, it becomes brittle. Every future defendant studies the outcome. Every judge recalibrates tolerance. The room remembers. What looks like a decisive moment can become a template, repeated under less controlled conditions. This is the point of no return, not because of punishment, but because of precedent. The idea that courtroom authority is conditional has either been disproven or confirmed. There is no middle outcome anymore. Whatever happens next will be cited quietly for decades, long after the names involved stop mattering. The system is now operating without illusion. It is no longer pretending that patience alone can absorb defiance. It is choosing between coherence and convenience. And that choice, once made, cannot be undone. What follows will not feel dramatic. It will feel procedural. Filings, deadlines, decisions delivered without flourish. But underneath that calm surface, the recalibration is permanent. One version of the system will survive, another will disappear, and the unsettling truth is this. By the time the public notices the outcome, it will already be over. The real decision has already been set in motion. The rest is just the sound of the machinery finishing its work. There is another layer here that rarely enters the public discussion, but inside the legal system, it is already being weighed with extreme caution. Criminal contempt at this level is not just a sanction against behavior. It is a stress test for judicial legitimacy in a polarized environment. Once invoked against a figure of this scale, it stops being an internal corrective and starts functioning as a signal to every other court in the country. Historically, federal judges avoid this path precisely because it creates secondary vulnerabilities. Appeals multiply, claims of selective enforcement proliferate. The judiciary becomes part of the narrative rather than the referee. That risk is usually enough to keep even severe misconduct contained within civil remedies. When that restraint is abandoned, it means the calculus has changed fundamentally. Another rarely discussed consequence is procedural acceleration. Once contempt becomes criminal, timelines compress. Decisions that might have unfolded over months are forced into weeks. Prosecutors lose the luxury of delay. Judges lose the option of ambiguity. Every move becomes legible, recordable, reviewable. The system trades flexibility for clarity, knowing that clarity is safer than drift. There is also the internal effect on juries. Not just the ones seated in this case, but future juries watching from a distance. When a court demonstrates that it will enforce silence, removal, and prosecution if necessary, it reshapes expectations of what a courtroom is allowed to be. Not a forum for persuasion, not a stage. A controlled environment governed by rules that apply regardless of status. And then there is the political aftershock that institutions privately fear. Once enforcement is visible, it cannot be selectively unseen. Supporters frame it as repression. Opponents frame it as accountability. But neither framing changes the institutional reality. The judiciary has crossed from passive endurance into active preservation. That move narrows the range of acceptable outcomes going forward. What follows is not resolution, but stabilization, or failure. If the system holds, it does so by becoming colder, more formal, less tolerant of disruption. If it fails, it does not fail loudly. It erodes quietly as future defendants test the same boundaries with increasing confidence. This is why the moment matters beyond the individual. It is not about punishment. It is about whether authority can still be exercised without negotiation, whether rules still function as constraints or merely as prompts. The unsettling part is that no matter how this concludes, the precedent is already alive. It is being studied in chambers, cited in memos, discussed in cautious language behind closed doors. The outcome will shape behavior long after the names involved fade from relevance. At this point, the system is no longer reacting. It is committing. And once that commitment is made, there's no rewind, only continuation.